Kuna jiko hapa. Kuna jiko nyuma yake buda. Mono. Wewe kuchangamkiza vyombo. Fungue kidogo.
Watu kaitha remwe twambe tujue macani na ki uri micinga ingi irareho inaonekana kama yote inaletwa kwa police station hapa popote walete tu kama ni lori mzima kijana hinya unajua hata ule mtu alikuwa anatusumbua saa hizi hapa na mashida mingi sana Dada kachai. Silia. Chai. Unaenda mikono bure. Sawa. Sawa. Mama Irene. Eleka kombe. Ndio maskari.
Ukikana mutongoria kuria wigua we ukikana mutongoria kuigua tukimwendeta tuthumice gutiri mundu igate
ndona ntwambiriria ndona githe twakiona mĩcinga ĩngĩ nĩ yambĩrĩria kũrehwo reke tuone tweterere njanji oke
Sikiliza. Nani? Dunia unaniambia?
Testimony by PW5, Inspector of Police Samson Tanui. The said officer and witness for purpose of these proceedings, under the guidance of Mr. Njenga, the learned prosecutor, sought to mark for identification a toy pistol, which in his testimony said to have been part of the items recovered during the alleged search. Mr. Njiru's objection was that the said item ought not to be marked in two folds. First, that the same is being introduced to the proceedings for the first time by the witness, and secondly, that it was not made available in court when PW1 and PW2 testified, hence were the items to be admitted in evidence then they clearly would have lacked an opportunity to cross-examine PW1 and PW2 and to cross-examine PW1 and PW2 on the same and act according to him would prejudice the defense. Mr. Biko submitted in support of the objection. His submissions, though, were in form of question. What stood out is the question as to when investigation would come to an end, since according to him, the investigations in this case appeared endless. He submitted further that the defense had every right to be supplied with every evidence the prosecution sought to rely on. Mr. Ondieki also, in support of the objection, placed reliance on Article 50 of the Constitution with greater emphasis on the requirement that the defense ought to be supplied with all the evidence to be relied upon by the prosecution during trial. He held the view that what is sought to be introduced by the prosecution through PW5 is outside what was applied to the defense. It is on that account that the attempt to introduce the exhibit should be rejected in its entirety. The prosecution held a different view. In a rather insensitive tone, Mr. Omwenga, learned prosecutor, described the objection as that with no basis whatsoever. He gave the following reasons for his view. First, that the disclosures in the matter was made way before the case commenced. He submitted that they supplied all the documents they intended to rely on and was served to the defense, which included with specificity photographs showing the subject toy pistol. He submitted that he was unable to put the subject toy pistol to the witnesses who testified earlier, since the said items had been taken to the ballistic examiners as at the date the four witnesses testified. He did not see any prejudice that shall be visited upon the defense should the witness be allowed to identify the subject exhibit. Mr. Njiru reiterated his objection on rejoinder. He added that Article 47 of the Constitution provides for equality before the law and fair administrative action. He submitted that PW1 made reference to a homemade pistol, and what the prosecution seeks to introduce is a toy pistol. He submitted, contrary to the prosecution's position, that there was no indication on the date the four witnesses testified that the subject exhibit was still with the ballistic examiners at the time. He submitted that there must be certainty to a trial, hence stressing Article 50 of the Constitution. Two, in rejoinder, Mr. Ndubi H. appeared to be taken aback by the prosecution's assertion that investigation is a continuous process. He submitted that there must be certainty of trial and that there is need to play within the set legal procedures and rules. The prosecution therefore ought to be confined to what it supplied to the defense. This is the determination. Sanctity of Article 50 of the Constitution has not been brought to question. The prosecution is under a requirement to inform in advance the person charged of the evidence it intends to rely on and must afford a reasonable access to such evidence to the person charged. Article 47, similarly, on fair administration action is succinct. In relation to this case, it is the defense contention that the item sought to be introduced by the witness, being a toy pistol, first, was not part of the items applied to the defense. And secondly, that the defense will lose an opportunity to put questions respecting the exhibits to PW1 and PW2 are there testified should the witness introduce the item. Clearly, on the date of the taking of PW1 and PW2's evidence, the subject exhibit was not available in court. The prosecution, in what appeared to be in passing, indicated that the said exhibit was with the ballistic examiners, hence was not made available in court on the date PW1 and PW2 testified. I'm minded to agree with Mr. Njiru that what PW1 made reference to was a homemade pistol. That is clearly recorded in the proceedings. What PW5 seeks to mark for identification is a toy pistol. No indication, though, has been made whether it is the same one that was referred to by PW1 as a homemade pistol. This court, by dint of marking is not seized of those marked exhibits. As pointed out above, the defense assert that they are interacting with the subject exhibit intended to be marked for the first time as being sought to be introduced by PW5. According to the proceedings of this court, I was treated to the question of disclosure way before the commencement of the substantive hearing of this case. I gave direction respecting the disclosures. For clarity, on the 20th of June 2023, Mr. Ondieki made an application respecting the exhibits captured in counts 8, 9, and 10 on the face of the charge sheet. The exhibits in question included the subject exhibit. Similarly, in the evidence of PW2, and particularly in marking PMFI 19, is stated as follows, quote, the toy pistol appears in photograph number 11, 12, and 13, end of quote. Can it therefore be said that the subject item is being introduced to these proceedings for the first time? The answer to that is an obvious nay. The defense part of the objection, which I truly agree with, and as put forth by Mr. Njiru, is that the physical production of the subject item at this point deny the defense an opportunity to question the four witnesses on the item. I agree. It is to that extent that I disagree with the prosecution's view that no prejudice would be occasioned to the defense. Denying the defense that opportunity would clearly cause prejudice. This then sets me to the final question as to whether locking the item in question out of the proceedings via this objection would be an appropriate remedy. The subject item, that is a toy pistol, is a critical component for proof of count number 10, the foundation which is being laid by the prosecution through the evidence of PW5. Disallowing the marking of the item would bring to collapse that count at this stage. Are there available remedies available to the defense if the contrary is held? The response to this is yes. The Criminal Procedure Code makes provision for application for recall of witnesses for further cross-examination at any stage. This is an appropriate remedy that is available and open the parties. This court is under obligation to do what would give rise to an ultimate justice. In the end, I allow PW5 to mark the exhibits for identification, and the witness shall adequately be cross-examined on the same. Consequent thereto, and with a lot of respect, the objection is overruled.
You're most obliged.